everyone. My name is Jenny Brown, and I am the owner of Farmer and Brown Law Firm in Marietta, Georgia. We practice family law, and we are having a webinar workshop today focusing on estate planning and just some general answering some questions that we frequently hear. And I'm really excited that Amy has agreed to join us today. She is the owner, founder, and attorney of Atlanta Wills and Trusts Law Group. She's an educator, she's a speaker, she's an author, and definitely the expert in the field. So Amy, thank you so much for joining us. Can you tell us just a little bit about you and your firm?
Absolutely, and thank you so much for having me. I really appreciate it. This is kind of one of the things about my ownership of a business and my career and my job that I love, which is education, as you mentioned. So I'm a mom, I'm an attorney, I am a business owner, and I wasn't always, though, I didn't grow up actually wanting to be an attorney. It never crossed my mind to be an attorney as a young child. I actually grew up wanting to be Indiana Jones, and I still want to be Indiana Jones. I have this massive obsession with archaeology and anthropology. I actually have a degree in it as well, but I found myself one day, I was raised by a single mom, and I was raised in a family of all women. So one day I found myself at this crossroads. It had to do with some financial crisis that was happening in my household at the time when I was younger. And I made this decision and I became an attorney, and I just thought all attorneys were wealthy. I had no idea. I'd never met an attorney before. So I went to law school. I was a very good student in school, so I was able to go to law school and get into a law school, and I graduated and I started working in big law. And I started out in a completely different area of law, and I was really good at it. Just because you're good at something doesn't mean that you should do something, though. For the rest of your life. And so I chose to switch careers over a decade ago. I switched careers into estate planning. And one of the things that I brought with me was my ability to educate. I was a litigator, just like you, Jenny. And again, I was really good at it. And one of the things that I loved the most about it was speaking directly to the jury. And talking to them and explaining to them. And I just realized I love to tell stories. And one of the things I also loved about being a litigator was really trying to get someone's point across, their story across to someone else. And so when I became an estate planner, I actually became an estate planner because we had a severe illness and then death in our family of someone who was kind of the linchpin that held my family together. And as a result of her passing, my family somewhat spiraled out of control, as far as there was a lot of infighting when she passed away. There was a lot of disagreement about what people were supposed to get. It was really a kind of an eye-opening experience for me. And I realized I can help other families. Like, this is something I can do. I know how to do this. I can tell people stories. I can make sure that their voice is heard. I am really, really good at this. So I changed careers and I focus on women because, again, I grew up in that household of all women. And I recognized even as a very young child, I recognized very early on that my mom had to fight differently to have her voice heard usually. And we grew up in a Catholic conservative community. And so she was the divorced woman on the block. And so it was just a really unique experience. So I do uniquely focus on women because, frankly, we're going to outlive all the men, statistically speaking. We're going to take care of everybody along the way as we outlive them all. And because we're the caregivers, we really need our voice heard in the estate planning story. So I just talked a whole bunch.
No, and I think something that you teach that I also think is so important is that it's really never too early to create your plan, and it's about providing clients a plan, right? You're not just planning for a disaster. You're planning so that everyone knows what to expect when something happens, and it's never too early to start thinking about that and preparing for that. And as your family evolves, obviously that's going to evolve too. But we're in the situation right now where my in-laws are just now thinking about their estate. And it's amazing that they've been married for 40 years and they've never had the conversation of what one wants when they pass. And so it's always surprising that people don't think about their estate until they're pushed to the position where they have to.
Yeah, I mean, generally when someone is coming to see me, it's because something's happened. They've seen something happen with another family. They've, experienced something in their own family and they've seen something go wrong, which is unfortunate, but you're right. To me, I believe that all the discord, all the disruption, can actually be eliminated. If you just kind of upfront talk about expectations, talk about things, and I get it. I mean, I talk about death. I mean, I talk about tough things. But it's really important. I mean, it's going to happen, and it's going to happen on your terms, or it's going to happen on somebody else's terms, and no one's going to know what you wanted.
Exactly. So one thing I did forget to mention, if anyone has any questions along the way, they can post. There's a Q&A section, and Amy and I will jump on that at the end and try to answer any specific questions that come up along the way. But Amy, let's just jump right into wills. So in general, in Georgia, what happens if someone passes away without a will at all?
Okay. So I'm gonna, if it's okay, I'm gonna take one step back, just a little bit from the will. Okay. And I'm gonna do this because my 15-year-old son asked me the other day, Mom, what is a will and what is a trust and what do you do? So I kind of stepped back with him, but this is actually something I step back with a lot of individuals, and I kind of do. So the really straightforward way to think of this is when you pass away, you can no longer own things. It's just plain and simple. You just can't. Okay. And there's probably all sorts of ways that people can semantically work around that statement, but just as a general rule, if I die, I can't own anything any longer. So what a will, or if you pass away without a will, everything that you own will go to other people, but it will not go to other people on your terms. Instead, there are a series of laws that Georgia politicians have created over the last couple hundred years or whatever. And actually they date back to like ancient common law from Great Britain, that basically will decide what you owned in life, who gets it after you die. Those laws are called the intestate laws. Okay, so basically there's already a decision out there. The state of Georgia has an estate plan for you. They have a will for you. Now, if you do a will, it will replace that. So instead of Georgia getting to decide what happens to your things after you die, you get to decide. So estate planning is really about your choices and whether you want someone else to decide for you what happens. So a will take what you had during your lifetime and give it to whom you want to, that you've stated in your will. After you pass away, a will only works at death. That's kind of an important thing. So if your line of, this is your lifeline here, and a will only takes place after you die. It is not necessarily, you can change it up until the moment of death, as long as you have capacity to do that. But that's what will happen when you die, and the will will actually help decide who gets your stuff.
Oh, Amy, can you hear me?
I can hear you, yes.
I'm having some, hold on 1 second.
And your video is clear for me as well.
Hold on, can you hear me?
Yes, can you hear me?
I can, let me, 1 second, I'm having some, the internet seems to be cutting in and out.
I think I just heard my teenager wake up. So all the teens are probably waking up across the country, beginning to use the bandwidth. All right. I did lose your video. I'm not sure if anyone else can hear me, but definitely if you have questions, just remember to pop your questions down and we will definitely answer your questions along the way. All right, for those of us just joining, if you can hear me, hopefully you can. Okay, perfect. All right, good. Okay, so thank you, Sam, for letting us know that you can hear me. I think that perhaps Jenny and Sandra have experienced just a little bit of internet instability, not unknown to all of us, going through everything and everybody using the same internet. So one of the things that I think that I'll share with you, since the attendees can hear me, while Jenny and Sandra are hopping back on and us moving forward again with the webinar is, so again, as I mentioned to you, if you have a will, you basically are replacing what the state of Georgia has decided it will do for you, or it will do with your stuff when you die. So a dead person can't own stuff. It's either Georgia's going to decide what happens to it in terms of they have their own little laws. And if you have a will, then you get to decide. So generally speaking, if you don't have a will and you pass away, here are the general sort of breakdowns of what happens to your things. So I'm married, and if I did not have a will, then my husband does not receive 100% of my estate. So if I have $100,000 in the bank account and only my name is on it and I die, then my husband will not get $100,000. Why? Because I have 2 children. So generally speaking, if I did not have a will, the laws of the state of Georgia would actually give my husband 1/3 of that money and each of my children 1/3 of that money. Now there are also some special rules around that, but what I want to make clear is something that a lot of individuals come and talk to me about. They do not realize that their spouse will not get 100% of their estate. Now in some states, that's what happens. But in the state of Georgia, a spouse does not 100% inherit from the other spouse. So again, yeah, I can see you in the background. Yep, I can see her.
Sorry, Amy, we're having some technical difficulties today.
No, it happens all the time. So that everybody could hear me still. So I just kept kind of talking and sharing.
Great.
And so that's a common myth here in Georgia. That is, your spouse inherits 100% of your estate. That is not true if you do not have a will. Now, again, as I mentioned earlier, you can correct that if you want your spouse to receive everything. And to be really, really clear, if you have minor children, you need to take care of some things because it's a very big, messy situation. If I passed away and I have 2 minor children, I have a 15 and almost a 17-year-old. So under the age of 18, they're considered minors here in Georgia. They don't think they're minors, but they think they're adults. But 15 and 17 still considered minors. So if I passed away without a will, my husband gets 33 1/3, and each of my teenage children would get 33 1/3. And then there would have to be some additional court proceedings, because my children, even though they're minors and even though they get the money, they can't control money until they're 18. So there would have to be somebody officially put in charge of their money until they're 18 years old.
And that brings up a really good point, Amy. I think a question that we hear a lot is, someone is, about to get married for the second time, or, potentially divorced for a second time, and they have children from a prior marriage.
Mhm.
How would that work if they were, married on their second marriage and passed away with no will? Is the rule still the same as far as your current spouse and then your biological children?
Rules are still the same. So your new spouse will be entitled to a certain portion of your estate. Now, there are probably some arguments to be made in there about how much money the spouse came into the marriage with, and similar to if it's a marriage that ends through divorce and a marriage that ends through death are treated differently. Sometimes there are some similar arguments in terms of this wasn't marital property, but go into estate planning thinking that marriage ending by death is a very, very different situation. And you can't assume that the court would say this spouse had everything before the marriage started, and therefore the new spouse is not entitled to any of it. Because not only is it a very different breakdown of what happens, it happens in two different court systems here in Georgia, actually. So if and I've actually helped families and helped clients who were in the process of a divorce. One of the spouses passes away. What generally happens is this entire divorce proceeding just kind of goes away, it collapses, and an all new case will open up in the probate court. And so it's almost as if you could argue all of these agreements that are beginning to happen over here in this divorce proceeding would almost have to start anew in this estate proceeding. So it's a very different situation. But back to your original question, which is, when you, and I see a lot of second marriages here, and I always tell individuals, at the end of the day, if I passed away, I would want my husband to be happy. And if marrying someone else made him happy, then I would want that. But I would also want to ensure that, and I think to be open and honest about it, we're young. There's a really high likelihood. In fact, statistically speaking, there's a higher likelihood that he would remarry than I would remarry if something happened to him. But if you are in a second marriage or contemplating a second marriage, and either spouse or both spouses have children from a prior relationship, then it is really imperative that you not only do estate planning, but you be honest with each other about what you want. Because the same rules will apply. So here's a situation. If I pass away, my husband remarries, and then he does an estate plan, and he does something called a sweetheart will, which is the sweetheart will is what we refer to as I give my spouse everything. Okay, so I want my spouse to be happy. So the second spouse gets everything. And then my husband passes away. Technically speaking, the new spouse will not automatically give my children anything. So you cannot assume that the new spouse would give your children anything. You have to plan for the new spouse to give your children something. And it's not to say that they wouldn't have a great relationship. It's not to say that they would be, it would be, like a acrimonious situation, but, humans are humans.
Yeah, and I think it comes down to just planning and really being upfront about what's most important to you. And as a parent myself, my main priority is my children, whether it's with my husband or if, God forbid something happens to him and I get remarried, it's still going to be ensuring that what I've worked for and I've built, that my children are benefiting from that. That doesn't mean that you don't want your spouse to benefit as well. But situations can get so messy and you have no control over it if you are no longer here. So I think that, especially with the amount of second marriages that we see, getting all of this worked out, it's very similar to importance of a prenup, right? So you're preparing, you're not doing a prenup expecting you're going to get a divorce, but you're eliminating so many of the issues that come with a divorce. And I think estate planning is the same. Something I did want to talk about is power of attorney. So what I've had clients, ask me, or I've heard people say is, well, if I have a power of attorney, why do I need a will? And just really explaining how different those things are to people, how they're not the same at all. But just generally, what is the difference in a power of attorney and a will, and why do people need them?
Okay. So in the very beginning, I talked about this lifeline. And your will only takes effect after you die. It has no impact whatsoever while you are alive. The opposite is true for a power of attorney. So a power of attorney is only effective while you are alive. It only works while you're alive. And for the most part, and this is almost a blanket statement across the US and every state, it ceases being valid when someone dies. So so you have the lifeline, and so powers of attorney work here, you pass away, and then the will picks up. So much of the same functions will end up happening. You know, somebody is going to be in charge of things for you. It'll happen for different reasons, but there's that line that basically stops the validity of a power of attorney and then picks up the validity of a will. And frankly, they actually work for very different reasons as well. So of course your will works because you're dead. The power of attorney can work for various reasons. So what I always say is your power of attorney only works as far as the power that you're giving someone. And there are two main areas that you can give someone power: health decisions, which I think we'll talk about a little bit separately later, but financial decisions is the big one to think about. And so a power of attorney is you giving someone else the power to act as you in a financial transaction. And sometimes people do that immediately, which means I have a power of attorney and I've given my husband the ability to act as me right now, no questions asked, in any financial transaction. So he can walk into a bank on an account that I own exclusively, and he can transact business with this document if I've given him the power to do it. Some powers of attorney only work after you've become ill and are completely incapacitated. And so they work very differently, but they work during your lifetime. And you can't rely on a power of attorney to do the same thing as a will, because first of all, that's not the power you were given. So generally, a power of attorney does not give somebody the ability to completely distribute your things as if you're dead, and to transfer ownership, sell things, all of those things. It usually gives someone the ability to help you when you need help.
And so there's certain triggers for a power of attorney, just like you talked about, whether it's the financial or the medical. What about ending those power of attorneys? Does divorce automatically end those, or do people need to do something to make sure that those are revoked?
So what a formal entry of a termination of marriage, right? So it has to come to a full end, really, to be truly effective, because a proceeding can take a long time, right? And it could be short, but there's really, the general length is probably much longer than, say, 30 days for a divorce proceeding to happen. So until it's truly ended, a marriage has ended through divorce and through entry of a court decree, then that power of attorney can still be considered to be valid potentially if you've given your spouse that power and you've given them the immediate ability to act. As I mentioned earlier, I give my husband the immediate ability to act, to go walk into Chase Bank. But there are some steps that you can take. So while you are in the middle of a divorce proceeding or a formal separation, even if a divorce hasn't started formally, but you're legally separated, you can revoke the power of attorney. And there are steps that you can take to do that. Usually you want it to be in writing. Once you revoke it, you really should replace it with another one. So there's the difference between revoking it and just basically making it evaporate and go away. But you also want to put something in that vacuum and replace it with a new one. And so you also need to notify the individual that you had appointed. So if I appoint my husband, then we begin to have, or we begin a divorce proceeding, I need to notify him, and it really should be formally in writing, that he is no longer my power of attorney and that he should not act. And in fact, you should actually ask for all the copies and anything that he might have or she might have in their possession. That is something you are allowed to do during your divorce proceeding in estate planning terms. There are some things that you're not allowed to do without permission with your assets, but you are allowed to revoke your powers of attorney for health and finance. Now, once your marriage is actually formally ended through an entry of order, your power of attorney, if you have not revoked it up to that point, does not get revoked automatically. But if you've named your spouse is removed automatically. So what I recommend is, if you have not replaced or completely formally revoked and replaced it up until that point, that's the moment you really should do it. Because right now you have this power of attorney running around out there, and not every bank knows that your divorce was finalized and that person is no longer your spouse.
Well, I think you said something really important as well, is that these powers are revocable. And I think people really need to see the importance of that, yes, you've, created this person as your power of attorney. And maybe when you're single, it's your mom or your sister or something like that. And you're preparing, but you can always update those and you can always replace those depending on what's going on in your life. But just having that established is so important.
So what I tell people is, and I tell this all the time, any aspect of your estate plan can be changed, whether it's a power of attorney or your will, or if you have a trust that we haven't really talked much about, as long as you have capacity to do so. And generally speaking, everyone has legal capacity unless you have some form of illness like a dementia or an Alzheimer's. You generally have capacity to change these items. And so if you want it changed, change it.
Yeah, and I think it's important that you seek someone who is specialized in the field and making sure that you're taking all the steps that is necessary to change it and update it and replace it. Because 9 times out of 10 in reality, when you're changing it, it might be because of a conflict, and there's no guarantee that you're going to get those back. So making sure that you're talking to someone who has seen how these situations can turn, and taking care of that the correct way to make sure that you're protected and that your assets are protected.
Right.
Let's jump into, while we're on power of attorney, the health, and then we'll start a little bit just about trusts. So can you tell a little bit about the power of attorney for health decisions, the medical power of attorney?
Yes. So in the state of Georgia, this document's called an advance directive for healthcare. So that's what we in Georgia call it. It's the name of the document. Other states are going to call it other things, but generally speaking, I think this category of documents are called healthcare or medical powers of attorney. So they do the same thing as finances. In an advance directive, you're giving someone the power to make decisions for you in a healthcare setting, as if they are you. Generally, you're also giving them the ability to access your private healthcare information, like through a HIPAA document. The document you sign when you go to the doctor every time that no one ever really reads, but it's the document that basically allows them to get paid from their insurance company. It's called HIPAA, HIPAA. And well, that's the acronym for it. That is also included in this document. So what this document does is, I always say it's 3 parts. The first part is your general treatment decisions. So you're allowing someone to either help you advocate for the treatment decisions you want, or to speak for you in the general treatment decisions you want. The second area that it covers is, how do you want your remains to be treated after you pass away? And this is the one caveat that I mentioned, that your power of attorney stops working at death. This is the one area that kind of overlaps, which is, do you wish to be buried only? Are you okay with cremation? organ donation, autopsies. So basically, how do you want your remains, your bodily remains, to be treated after you pass away? So that's the second area that this document covers. And then the third area is something that's very prevalent in everyone's mind right now, which is end of life decision making. So I talked about treatment decisions earlier. End of life is different. So there are two different things. So general treatment decisions are, do I have generic medication, prescription medication? Do I have name brand? Do I want to have surgery? Do I want to try a diet regime first? So those are just general everyday treatment decisions. End of life is different. A medical professional, typically multiple medical professionals, have indicated that your end of life is near, that all treatment options are not working, and there is no potential for recovery or a cure. So they're two very different areas and very different things. End of life decision making is when those medical professionals have made that and indicated that end of life is near, and that whatever treatment and procedures you are receiving right now are prolonging that moment. So it's drawing out that moment longer, and they want that. So that part of the document is, you know, the one that relates to, do you want those procedures to be removed, or would you like them to keep going? And so there's a lot of discussion that I've been having, especially now, around that area specifically. And we could have a whole new webinar on whether or not COVID-19 and what's happening if you do end up ill and in, say, an ICU with regards to this. That's a whole other webinar. But I would just say that generally speaking, your end of life healthcare decisions are not necessarily what's happening right now. It's a different thing. Treatment is continuing because there is a chance of recovery. So.
Yeah, and something that I find so interesting about the medical decision is that it's so easy to assume that someone would want what you want, but then put in the situation where you're actually making a decision for someone else, the amount of comfort that you could have as an individual knowing that you are doing what they want is just so important. And I talked about my in-laws earlier, but they've been married for 40 years, and we started talking about their end of life decisions, and they were on opposite ends of the spectrum as far as what they wanted in regards to medical treatment. And they were both surprised at the other. And it was just so interesting to see, because they've lived in a happy marriage for 40 years and never had the conversation. They just assumed that they both would want the same thing. And now there's this level of comfort of, okay, I know what to do for my husband, or I know what to do for my wife, that they just didn't have before.
Yeah, my poor family, I share lots of things about my own family all the time when I'm talking. And because we've had many things that sort of have illustrated this. My grandfather had Alzheimer's, and he had several forms of dementia as well. But before he did, he passed actually after my grandmother. And so I went to him and I said, you know, Grandpa, you really need these documents in place. I had started doing estate planning, and I was like, you need these documents in place. And so he put his documents in place. He got these documents in place. And by the time he passed away, we did have to remove procedures. He was on procedures that were prolonging his life, and that is not what he wanted. And we knew that. And my mom, who had been his caregiver, had been so emotionally invested that she point blank told me after he passed away, that she was so grateful, because she did not think she could make that decision, because she had been so emotionally invested in helping him stay alive and caring for him. And she lived with him to care for him. And she, there were a lot of things going on in our family at the time, a lot of probably not very functional and healthy things going on as far as relationships, but she was not in a good place to have answered the question for the doctors if my grandpa hadn't already had it in writing So she said that she will never feel guilty over making that decision because she didn't have to make the decision. He made it for her. So what I tell my families is don't ever put your spouse or your adult children in a position that they have to feel guilty and question what they did for you at the end of your life because you chose, and this gets a little harsh because you chose not to face the hard decision during your lifetime. Like, I'm a mom. I would never want to put my children in the situation where they didn't know what I wanted. Once they become adults, like it's kind of a little easier to say, yeah, my husband will do it, right? Like, okay. But once I become an adult and my kids are taking care of me, yeah, I would never want them because I just wasn't able to answer the tough question while alive, or I didn't take the time to put it in writing. And I don't say that to people lightly, but I've just seen it play out in my own family that, my mom now doesn't have to feel guilty because
And I
my
think
grandpa did do it.
that's such an important thing, is that you're not only planning for what's happening with your assets and who you're giving certain things, you're really giving them a sense of just freedom and knowing that they did something, like you're giving them such relief of knowing that you chose this and that they don't have to wonder one way or another. And that's such a huge gift, just as much as any asset that you could leave for them.
Yeah, I say estate planning is about the gift of choices. It's got nothing to do with money. It really doesn't. It's about the gift of your choices and preserving relationships in your family. Because when someone doesn't know what someone wanted, there are these gaps, and in the gaps is where the chaos and the discord happens. And so if you can eliminate the gaps of questions of what someone wants, you can preserve the relationships for your children in the future to have a healthier relationship together, for future second spouses, third spouses, whatever that might be. So it's about preserving the relationships and the gift of your choices.
Yeah, that's great. Let's jump to trust. I think there's a lot of confusion around trust, right? A lot of people who don't know anything about estate planning, they'll say, oh, I need to do a will and a trust. They just go, they just slap them hand in hand and don't really understand, is there a difference and what is the difference? So can you give us a general overview of really how they differ and what a trust is?
Yes. So if you can think of a box. So a will is, as I mentioned earlier, it's a document that will give your stuff away after you die. All right. A trust is a wooden box. All right. And you can build the box while you are alive, hence the words living trust. Okay. So you can be a carpenter and you can put your trust together. So you build this wooden box and you put things inside the box to safe keep. So you're like, I can put this pen in the box. I can put this hair clip in the box. And I can put all sorts of things in my box. I can put my home in the box. I can put bank accounts in the box, but it is a wooden box. And what this trust does is when you pass away, it will safe keep everything inside this box. And your will, on the other hand, has to go through a court proceeding in order for your stuff to get distributed, but a trust does not go through that court proceeding. So it will do the exact same thing as your will, which is make sure that all of your things go to the people you want them to go to, but it avoids a court proceeding to do it. So the court proceeding, when you have a will, is called going through probate administration, like estate administration through probate. In a trust, this wooden box does everything that the court does. So you avoid it. And so you have avoided court time, you've avoided court costs, you've avoided attorney's fees associated with that at the end of your life. You also are going to have a few other features that a will cannot give you. I have minor children. And so I have a 15 and a 17-year-old. In the state of Georgia, I mentioned earlier that an 18-year-old is no longer considered a minor child, and they can inherit from you and receive things from you. Well, I do not want my 18-year-old child to receive things from me. I don't want they're going to be dealing with grief. from losing a spouse, a parent. They're going to, potentially watch, depending if it was an illness or not, or something tragic. Either way, I don't want my 18-year-old, I wouldn't even want them if they were 20. I wouldn't even want them if they were 23 or 25 necessarily to inherit whatever monies that my husband and I are giving to them. You cannot control that in a will. At 18, they get the money, no strings attached. You can't tell them to use it for education. You can't tell them to use it to invest, buy a piece of real estate. I joke that my son would buy the best gaming laptop he could get his hands on and a really cool pair of sneakers, right? I don't know. It's like, so what kinds of decisions would they make at 18, at 20 with that amount of money? Would they still go to school? Would they be dealing with grief in other ways that could even turn them to someone or something that is unhealthy? A trust, if you have it inside this box, you can hold on to it for them. So you can keep it inside the box. It's still theirs. No one else gets it. You can still give it to your children. You put someone in charge of the box. You name that person. They're called a trustee. So if I have a box and I can name a professional trustee, so attorneys do it, banks do it, but you can also name a family member if that's what your choice is. And they look over the box for your children and everything that's in it for them. And then they can help pay for education costs. And then at whatever age you're comfortable in your children receiving that money, they can get the money out of the box completely, no strings attached. So it's like basically if you were a parent and your child came to you at the dinner table and they're 20 years old and they say, Mom, Dad, I have this really great business idea and I want $250,000. You would ask them a lot of questions. So the box kind of does that for you. It helps them mature. Trusts also, and you mentioned second marriages. That is one of the best ways if you are in a second marriage to ensure that you benefit your new spouse and your children from previous relationships. It is really one of the only ways to guarantee that if you are in a second marriage, that if you died first, that your children would benefit. Maybe not immediately, but at least some point that your children, you can basically marshal off money for them right there to hold on to in the box. So trusts work really well with second marriages. And again, they have some features in them. The two biggest features are they avoid the probate process and they hold on and safekeep money for someone until that person is ready for it.
I think that's really important because so many people have this misconception, I think, that a trust is just for the wealthy, right? So you have to have a ton of money to put something in a trust. But what I think about is even just life insurance policies. So someone is paying, they've been paying $20 a month for a $500,000 policy, and they want to protect that money and exactly what you're saying, and protect their children, and putting that policy in a trust so that you're making sure that you're not giving an 18-year-old $500,000 to, spend with his college buddies when he goes away to Georgia or whatever that, what an 18-year-old would do and is understandable in that emotional state and that age. And so I think that it might be important just to touch on the fact that trusts are not just for, the mega wealthy. They're not just for millionaires. It's something that anybody can really benefit from.
So that's actually a very common misconception about trusts, is we hear about trusts in terms of like corporate trusts in incredibly wealthy families. And in fact, those are not the trusts that I'm even talking about. So yes, those kinds of trusts exist. I actually don't even do those sorts of trusts. I refer someone to other people that I know because I don't enjoy doing that kind of work. I enjoy helping families that look just like mine. We all live in very similar communities, and I would say everyone that lives in and around us, the size of their estate is absolutely appropriate for a trust. Absolutely appropriate. And so, I've done trusts for, as you mentioned, merely to hold life insurance policies at some point. someone says, you know what, my family is young, we're just starting out. And honestly, it's not that we have a lot in the bank account. We probably don't have much equity built up in our home. We just started working with our 401ks. So those aren't large right now. So we do have these life insurance policies, and that is sometimes where we're starting. We're starting there, and that is a really appropriate way to handle money, because if your family is starting out, that means your children are really young usually, And so the older you get and the larger your estate sometimes can be, or a lot of times when I'm working with someone after a divorce, they're in building mode again, because sometimes it can be a financially difficult process to go through. And so they're like, well, I'm starting over. But here's one of the things about divorce and about starting, like if your estate isn't that large at that point, is you just went through this proceeding, and sometimes it can be a difficult proceeding to go through, and you had to negotiate quite a bit to get certain assets, and those are yours. If you have young children, then potentially you don't want it to go get controlled by the person that you just divorced from after if you passed away. And so a trust can help in that situation as well. But it's not the size of the estate that typically is what dictates whether you should get a trust or not. It's what do you want to have happen when you pass away? And if you don't want your children to receive money at 18, that's a good reason to have a trust. You don't want your former spouse to be controlling the money, good reason to have a trust. If you just want to ensure it's the person of your choosing that's controlling money, investing it for your children, being smart about it, then a trust is appropriate for you. It doesn't necessarily mean it has to be millions of dollars, but it definitely means that you have a choice and you want it to be heard.
And I think that you said something that was important as well, is that a trust is not just for accounts that are built up that you're not using, or that you have this big stash of savings. It's really just securing that asset. So even if it's just your checking and savings account, what's in there at the time you pass, you can still use that checking and savings account, but it's securing that asset.
Yeah, so whatever you put inside your box, it's treated the exact same way as if it wasn't in your box. So your bank account, you still use it in the same way. There's zero difference in the way you really use it. You can sell your house, you can buy a new house, all of it is exactly the same way. The difference happens instead of waiting for the court to give you permission to access a bank account, which can take weeks, and right now it's taking much longer than weeks, you can get access to it right away for your children. You can get access right away to keep paying the bills on the house to maintain its value so that it can get sold eventually. So it's about avoiding the time associated with court proceedings after as well. So yeah.
And we're about to jump into questions, but one question I have before we do that is, is there value to having a will and a trust, or do people have either or?
So I do both. So you should always have a will. And I call it like the safety net under the trust, like the big safety net under the trapeze. And so because you build your box and you put things inside your box, sometimes things don't get put inside your box, or it gets put inside incorrectly. And so you always want a safety net. And actually, your firm, you see accidents all the time, right? You can't plan for accidents. They call them accidents for a reason. And settlements and accidents you can never anticipate for. But let's just say I was hit by a truck tomorrow and I passed away, and there was a very large settlement, which I would hope my husband would get for me. And there was this very large settlement because I passed away, and that will allow him to take that money that was part of that settlement and put it into the trust. Because if you don't have permission to do that, that gets tricky in the court system, and you know that, right? So you want to eliminate having to go through the court system to do anything. So you always want a will. And so if you have a trust, you should also have a will. It's a very particular kind of will. It's a special kind of will. But you should always have a will. It's a safety net underneath your trust in case something doesn't get put inside the box correctly.
Great. Let me see okay, so we have, let's see, this says, Amy, what is your opinion on having your 18-year-old children designate a power of attorney and have an advance directive in place?
So I actually do these very specifically, and I don't know, can you guys still see me? Oh,
Uh-huh.
okay. All right. Um, so I have a package. It's called the College Power of Attorney Package, or Power Up Your Dreams. And I offer these to young adults and going off to college or heading off maybe for their first job or going abroad. And so I'm a believer that they should have them. It shouldn't look the same as, say, me at 46 years old. It shouldn't look this kind of the same way. There needs to be some certain provisions in there about education. They don't need to make necessarily all of the same decisions, but I do believe that they should have it. At the end of the day, once your child turns 18 years old, you no longer have the right to make decisions for them unless they give you permission. Even if they're on your insurance until whatever age they are on your insurance until, even if you're paying for college, you do not have a right to actually access certain things in their college records. It's really kind of like a switch gets flipped at age 18, and you no longer have access to make to healthcare information, which might be okay, but you no longer have decision-making authority. So if they're away at college and they become ill, unless they can give you permission and give the doctors the okay to talk to you, you might not be talking to them. And unfortunately, I do know parents who have had to make several very lengthy drives without knowing what was happening to their child until they got there, um, because no one would talk to them because their child was not conscious. We don't want to think that can happen, but this is a simple way to help that. So I'm an advocate for it.
And what about, is there any difference of if you have an 18-year-old in high school or, that's still in high school or an 18-year-old out of the house? Is it a strict line of, look, your kid is 18 and the rules are the same?
18 is 18. Yeah, and there might be some slightly different rules when it comes to accessing education information,
Mm-hmm.
but 18 is 18. I can tell you that 18 is 18 when it comes to healthcare decisions. 18 is 18 when it comes to finance decisions. The education bit might be slightly different because most high schools don't enforce that. But my daughter's going into her senior year of high school, so a lot of her friends are 18.
Mm-hmm.
So, I mean, they can walk into the school and say, I'm 18. You don't get to, my mother or my father doesn't get access to anything anymore. I
Yeah.
mean, they can say it,
Great.
and so not that they usually do, but I'm just saying that theoretically 18 is 18.
In your experience, what age do you think it's appropriate to start discussing probate and estate planning with your children?
Um, so what I say is this is where you're the parent and you know what's best. I would never tell you what to discuss with your children or not to discuss with your children at whatever age. What I would say is this, I think it's really important that if and when you do estate planning, that you let them know that you have a plan. That if anything were to ever happen to you, that you have a plan. Um, I think that I go back to this is the gift of your choices. This is the gift to your children of you taking care of them if you can't take care of them. And as a mother, that is literally the one thing in life that I don't want to think about, but I know how important it is to think about. It's so at whatever age you feel it's appropriate, if you get a cold or something, say, yeah, mommy needs to be taken care of because, I have a cold and I'm sick. And so and so is going to take care of me. My sister's bringing me chicken noodle soup and I have a plan. And so you can even approach it with younger children that way. I really, truly think that kids are so much smarter and able to handle these conversations than sometimes we give them credit for. So I would really venture to say that if your child is approaching the teenage years, that you really need to talk to them about the fact that you have an estate plan in place. And I would never tell someone that they should ask their children what they want, but we made a decision to talk to them about certain things in our estate plan. Now, it could just be because they're used to hearing these words around, because this is what I do. And they hear sometimes some tragic things when I come home and something happened really tragically, and it's very difficult for me to work through, and I'm processing something. But at the end of the day, it's really important that at a minimum, they know that you have a plan for them. And if they're older, I would recommend that you talk to them about it. If they're young adults, like 17, 18, 19, definitely talk to them about it, because they're going to want to know why you didn't put them in certain roles in your plan. As a really young adult, early 20s, if you should even be telling them where it's located. Because if Aunt so-and-so calls up and says, your mom's been involved in an accident and I need you to get the documents, you want your young adult child to be able to go to your house and find where those documents are. So it's a continuum, and it's about you as a parent and what you think your children is capable of understanding.
And I think there's a huge benefit to letting your children know that you have a plan, because at the end of the day, they want to know that there's something in place and what's going to happen. I mean, my daughter is about to be 6, and she already asks questions of, when you get old, what's going to happen. It started early of, when you get older, you're going to turn small. She had this reverse life cycle in her head. But I think that people really need to give credit to their children and the security that we can give them by coming up with a plan, letting them know that the plan is aligned with your wishes, and taking that pressure off of them of figuring out what you wanted or what they should do.
Yeah. And go ahead.
Oh, go ahead.
I was going to say there's a few pieces that I think people also need to think about when it comes to estate planning, and this might be a really good time to talk about it, because what we just spoke of, which is speaking to your children about the plan. So when we do estate planning for someone, there's a binder right behind me. You can kind of actually see it. It's green. And so legal documents are one thing, but what to do with those legal documents are another thing. Most people don't know what to do with the will when someone passes away. Most people don't know how to use this power of attorney. And so those are also really critical and important conversations that you should have. And when you're working with an estate planning attorney, they should share some of that information with you. So we actually give our clients like letters to give to the agent to explain to them how to use this document, what they can't use the document for, because they can't use your money for their benefit. Your money gets used for your benefit. And then kind of some initial things to do. We do something called a nomination of guardianship for minor children. It's a separate document that we do. They don't have a set form here in the state of Georgia, unfortunately, but we do like a pre-need nomination form for families in the event that there's an emergency or a permanent need, meaning you have passed away. And so that you can name the individual you want to care for your children if you can't. But you need to have conversations with that individual about what they need to do if you do pass away or you become incapacitated. So I go back to definitely speak with your children, but talk to your other family members as well. Talk to the sister that you've named in your plan. Talk to the grandparents if you haven't named them as the guardian, and let them know why. I know that's a really hard conversation maybe, but you want them to be grandparents. You don't want their lifestyle to have to be reorganized. For whatever reasons, talk to the individuals that you have named in your plan. At a minimum, you give them the name of your estate planning attorney. At a minimum, you let them know where the documents are. At a minimum, you say these are the first 3 things that you would need to do if you would need to use one of these documents. So these are really important things too. We call this the plan around the plan. You should have a plan, then you should have a plan around the plan.
Yeah, and I think that's a question that I've heard a lot is, okay, well, I've got the documents. What do I do with it? And people don't think that things are going to happen, but you always hear the story of, oh, they had a will, but the house burned down, and that was the only copy. And I think that comes back into, the circle of a plan around the plan, and making sure that there are a few people that know of your plan and are comfortable and have had those conversations well in advance where everyone is prepared.
Right.
Well, thank you so much for your time today. I'm really just grateful that you were able to talk to us and answer so many of just the common questions that we hear around estate planning. I have put your contact information here, and it will also be posted on our social media if anybody has any further questions or they need to reach out to you directly.
Well, I certainly appreciated coming on, and thank you so much. And just so everybody knows, I'm not sure I actually pronounced my name in the very beginning. So it's like Rebecca, but with an F. So Refeca. So when you reach out to us, and the name of my law firm is Atlanta Wills and Trust Law Group, and I'm up here in Alpharetta. We do help individuals kind of all throughout, especially North Metro Atlanta. I have a lot of clients actually from Marietta. I have a lot of clients from Woodstock, Canton, like Cherokee counties, all the way over to like Lawrenceville and beyond. It's just sort of like the whole kind of sweep. So I'd be happy to speak with anyone who is joining us today or happens to see this later on about, you know, their unique family.
Okay, well, thank you so much, Amy, and I hope you have a great day.
Thank you. Thank you for having me. You as well.
All right, bye-bye.